And we're back. All right, so let's jump back over to the video and get it going.
In substance, as a tax on the land itself, and hence a direct tax. This may be admitted for the purposes of the case, but it does not appear to in any way decide the question here at issue, or even to be very persuasive. The question there was of the power of Congress, under that clause of the federal Constitution which forbids any direct federal tax except one levied in proportion to the population. The question here is primarily of the power of the legislature of Wisconsin, under its constitution, to levy an income tax in addition to a real estate tax, and secondarily whether such tax denies to anyone the equal protection of the laws. The inapplicability of the rule in the Pollock case to the case here presented seems so plain as to require little comment. There can be no doubt of the proposition that income taxation of a progressive character, in addition to taxation of property, is directly authorized by the Constitution of Wisconsin as amended in 1908. Words could hardly be plainer to express that idea than the words used. From them it clearly appears that taxation of property and taxation of incomes are recognized as two separate and distinct things in the state constitution. Both may be levied, and lawfully levied, because the Constitution says so. However philosophical the argument may be that taxation of rents received from property to Pollock v. Farmers Loan and Trust Co., 157 U.S. 429, 15 sub. CT 673, 39 L. ed. 759. Is in effect taxation of the property itself. The people of Wisconsin have said that property means one thing and income means another. In other words, that income taxation is not property taxation, as the words are used in the Constitution of Wisconsin. 76 On the same principle, a tax laid upon the receipts or income arising from the conduct of a particular business, such as that of a banker or broker, is not invalid because the law of the state also requires persons engaging in such business to take out a license and pay a fee therefor, nor is the imposition of the tax on the income an unconstitutional invasion of the right or privilege granted by the license. 77 And so a merchant's income from his business is taxable under the law, although he is taxed also on his stock in trade. 78 Questions of a somewhat different order may arise when it is considered that the income tax laws of two different states, or of a state and the United States, may bear upon the same person in respect to the same income. But it seems that no constitutional objection can be based on the fact that two or more independent sovereignties subject the same property, subject to the jurisdiction of both or all, to taxation for their own separate purposes. Thus, it is held that a state is none the less entitled to tax the transfer of an estate by will or inheritance because some part of the property may be in another state and be taxable there under the same kind of a statute, or because the estate has already paid an inheritance tax to the United States. 79 So, the tax imposed by the federal income tax law of 1864, upon all dividends declared to stockholders as part of the earnings, income, or 76 State v. Freyer, 148 WIS. 456, 134 N. W 673, 26 AM. And Eng. N. Ka. 1147 77 Drexel v. Commonwealth, 46 Pa. St. 31, Birch v. Savannah, 42 Ga. 596 78 Wilcox v. County Commerce of Middlesex, 103 Mass. 544. 7 Appeal of Hopkins, 77 Con. 644, 60 ATL. 657, matter of daily, 100 app. DIV. 373, 91 N. Y sup. 858. Gain of any bank, was held to be assessable against the bank for the whole amount of dividends so declared, notwithstanding the fact that it had paid a sum to the state of New York, under a statute of that state imposing a tax against the stockholders upon the value of their shares, and requiring the bank to retain the amount thereof from the dividends due them, until it was made to appear that their tax was paid. 80 And that taxation of the same property by different governments is neither unlawful nor uncommon may further be shown by the following remarks of an English judge, made in an income tax case. There could be double taxation if the legislature distinctly enacted it, but upon general words of taxation, and when you have to interpret a taxing act, you cannot so interpret it as to tax the subject twice over to the same tax. But it all depends upon its being the same tax, and as the Attorney General has said, there is nothing to prevent either one legislature, or two legislatures if they have jurisdiction over the subject matter, imposing different taxes upon the same subject matter. Double taxation in one sense is common enough in the case of these companies which have their head establishments in one country and their business in another, although no doubt there is always a sort of grievance felt in reference to it. 81 But although accumulation of taxes in this way may be constitutionally defensible, undoubtedly it sometimes results in very heavy burdens. Under the laws as they stand at present, for example, a person engaging in a certain line of business, as, for instance, a tobacconist, might be required to pay, first, a license tax or fee to the United States, second, a license tax or fee to the municipality where he does business, third, a tax on the building in which his business is carried on, if he happens to own it, fourth, a tax on his stock in trade as personal property, fifth, so Central Nat. Bank v. United States, 137 U.S. 355, 11 sup. CT 126, 34 L. ed. 703. SI Stevens v. Durban Rudapurt Gold Min. Co., 5 Tax Co. 402. An income tax to the United States, 6th, a tax on the same income to the state. 23. Taxing aggregate income of family. Modern income tax laws have commonly provided that only one deduction of the amount allowed by statute as exempt shall be made from the aggregate income of all the members of any family. And the practical construction has been that this required the head of the family, in making his return for taxation, to add the income of his wife and minor children, if any, to his own. This has been objected to on constitutional grounds as making an unjust and unlawful discrimination. But the courts have not taken that view. Thus, in Wisconsin, it was said, objection is also made to the provision that the income of a wife living with her husband shall be added to the income of the husband, and the income of children under 18 years of age living with their parent or parents shall be added to that of the parent or parents. This is another case of classification, and it is only justifiable in case there is some substantial difference of situation which suggests the advisability of difference of treatment. We think there clearly is such a difference in this, that experience has demonstrated that otherwise there will be many opportunities for fraud and evasion of the law, which the close relationship of husband and wife or parent and child make possible, if not easy. The temptation to make colorable shifts and transfers of property in order to secure double or even triple exemptions, if there were not some provision of this kind in the law, would unquestionably be very great. There is no such temptation or opportunity in the case of the single man, or the man and wife who are living separately. 82 State v. Freyer, 148 WIS. 456, 134 N. W 673, 26 am. And EUG. N. 24. Validity of graduated or progressive tax. The constitutions of both Wisconsin and South Carolina contain provisions authorizing the graduation or progressive increase of the income tax, and in both those states the validity of this feature of the law has been sustained. 83 In Wisconsin, it was also objected that such an arrangement of the tax was in conflict with the provision of the 14th Amendment to the federal Constitution securing to all citizens the equal protection of the laws, but the court ruled otherwise. 8*. Moreover, in some of the states, the inheritance tax laws are also progressive, and in at least one it has been decided that there is no constitutional objection to them on that ground. 85 Thus furnishing at least an argument from analogy to support the similar feature of the income tax law. The only contrary decision was rendered in Hawaii, where the court decided against the constitutional validity of a graded income tax, enacted in 1896, and much resembling the federal income tax law of 1894, on the ground of its being in conflict with the provision of the Constitution that each citizen shall be obliged to contribute his proportion or share of the expenses of government. The law in question exempted all incomes below $2,000, allowed an exemption of $2,000 on all incomes below $4,000, and taxed all incomes above $4,000 without exemption. It was held that this was not proportional taxation, but unjust discrimination. 86 In regard to the United States law, where the ground of objection, if any there be, must be found in the federal Const. Wisconsin, Art. 8, 1, as amended in 1910, esse Statution and not elsewhere, it may be remarked that the income tax laws of 1862 and 1864 were both graduated, in the sense that they imposed a heavier tax upon incomes above a certain figure than on incomes below it. But apparently their validity on this account was never drawn in question. The Supreme Court of the United States, however, has held that no constitutional objection to a graduated inheritance tax law can be drawn from the provision of the Constitution that taxes shall be uniform throughout the United States. For the uniformity in taxation required by this clause is not an intrinsic but a geographical uniformity, and the phrase is synonymous with the expression to operate generally throughout the United States. 87 Probably, therefore, a similar decision may be expected in regard to the validity of the super tax imposed by the present income tax law. 25. Retrospective operation of statute on general principles and irrespective of explicit constitutional limitations, a statute imposing an income tax may subject to taxation the income of the citizen for the whole of the current year in which the statute is passed, that is, not only so much of the income as accrued from the date of the enactment of the law to the end of the year, but also that portion which accrued or was earned from the beginning of the year to the date of the law. For the year's income is treated and considered as one entire thing, not as made up of several portions or items. And hence, although the statute might be called retrospective in its operation upon a part of the first year's income, it is not retrospective in such a sense as to render it unconstitutional. 88 It is clearly perfectly constitutional as well as expedient, in levying a tax upon St. Knowlton v. Moore, 178 TJ. S. 41, 20 Sup. Ct. 747, 44 L. ed. 969. SS State v. Bell, 61 N. C. 76, State v. Frere, 140. Profits or income, to take as the measure of taxation the profits or income of a preceding year. To tax is legal, and to assume as a standard the transactions immediately prior is certainly not unreasonable, particularly when we find it always adopted in exactly similar cases. 89 The right of Congress to have imposed this tax by a new statute, although the measure of it was governed by the income of the past year, cannot be doubted, much less can it be doubted that it can impose such a tax on the income of the current year, though part of that year had elapsed when the statute was passed. 90. So the Wisconsin statute was held not to be invalid because it included, as part of the income to be taxed in the year of its enactment, profits derived from the sale of property purchased at any time within 3 years previously. 91. But the case is different in regard to the federal income tax. Until the adoption and promulgation of the 16th Amendment, Congress had no rightful power to tax incomes, unless on condition that the tax should be apportioned among the several states. Hence, if the present statute had attempted to tax the whole of the citizens' income for the year 1913, it would have included some gains and profits, which, at the time they were acquired, and when alone they could be described as income, were not subject to the taxing power of Congress, except on the condition mentioned. Hence it is provided that for the year ending December 31st, 1913, said tax shall be computed on the net income accruing from March 1st to December 31st, 1913, both dates inclusive, after deducting 5/6 only of the specific exemptions and deductions herein provided for. 8. Drexel v. Commonwealth, 46 Pa. St. 31. So Stockdale v. Insurance Companies, 20 Wall. 323, 22 L. ed. 348 91 State v. Freyer, 148 WIS. 456, 134 N. W 673, 26 AM. And N. N. 26. Objections as to title, purpose, and mode of enactment of statute. The Constitution of South Carolina provides that no tax shall be levied except in pursuance of a law which shall distinctly state the object of the same, to which object the tax shall be applied. When the income tax law of that state was adopted, in 1897, its validity was assailed on the ground that it did not comply with this constitutional provision. But as the title of the statute was an act to raise revenue for the support of the state government by the levy and collection of a tax on income, the court had no difficulty whatever in holding that it did distinctly state the object to which the tax was to be applied. 92. In the same case it was further held that the statute was not in violation of another provision of the state constitution to the effect that the General Assembly shall provide for an annual tax sufficient to defray the estimated expenses of the state for a year. It was argued that the income tax law attempted to provide for taxation for more than 1 year, regardless of the estimated expenses of the state for the years in which it should be collected. But the court held otherwise, saying that the tax is levied annually and is applied to the expenses of the state in the year in which it is collected, and the courts are bound to assume that the legislature, in estimating the annual expenses of the state, takes into consideration all the sources of income to the state, including the income tax, and fixes the general levy accordingly. In regard to the federal corporation tax law of 1909, it appeared that the bill, introduced in and passed by the House of Representatives, was a general bill for the collection of revenue, including, as one of its features, a plan of inheritance taxation, and that this part was stricken out by the Senate, and the corporation tax substituted. And it was argued that 2 Alderman v. Wells, 85 S. C 507, 6 S. 800. This rendered the act invalid, since the Constitution provides that all bills for the raising of revenue shall originate in the House of Representatives. But the court held otherwise, in view of the further provision of the Constitution that the Senate may propose or concur with amendments to revenue bills, as well as other bills. 83. 27. Objections to administrative provisions of Acts statutes providing for the taxation of incomes have often been subjected to severe criticism on the ground that they confide too much authority and discretion to executive and administrative officers, in regard to the settlement of matters of detail, to the construction of the machinery necessary for the operation of the law, and to the making of rules and regulations for its enforcement. but it may now be regarded as a settled principle of constitutional law that, although a legislative body cannot delegate its power to make laws, yet, having enacted statutes, it may invest executive officers or boards or commissions created for the purpose with authority to make rules and regulations for the practical administration of such statutes in matters of detail and to enforce the same, and also to determine the existence of the facts or conditions on which the application of the law depends. And there is a marked and increasing tendency to leave more and more of what may be called the detail of legislation to such officers and commissions, the legislature settling the general policy and outline of the laws on a given subject, and confiding to administrative agencies the work of erecting the machinery necessary for their practical operation and their application in particular cases. 84 For this reason it. 3 Flint v. Stone Tracy Co., 220 U.S. 107, 31 Sup. CT 342, 55 L. ed. 389 * Black, Const. Law, 3d. C. Per. CT. Is thought that no valid objection to the federal income tax law can be based upon the authority which it entrusts to the Commissioner of Internal Revenue, with respect to prescribing forms and making rules and regulations on various matters of administration, more especially as it does not go nearly so far in this regard as some of the earlier acts of Congress on the same subject, which were never successfully challenged on this ground. For similar reasons, the Wisconsin statute was upheld against the objection that it unconstitutionally authorized the State Tax Commission to appoint the income tax assessors. The court held that this was not invalid either as a delegation of legislative power to the Commission or as violating the constitutional guarantees of local self-government. 95 Objection is also made to those provisions commonly found in income tax laws which require the citizen to disclose the sources and amount of his income in sworn returns, which, under certain conditions, are open to the inspection of the public, or which require him to open his books and papers to the examination of the revenue officers or submit to interrogation concerning his business affairs. Such provisions, it is argued, amount to authorizing unreasonable searches and seizures, and moreover, in view of the possible use of information thus obtained, they may compel the individual to furnish evidence against himself in a criminal proceeding. But no decision sustaining such objections as these has been found. On the contrary, the courts hold that such provisions cannot be brought within the reasonable intendment of the constitutional guarantees referred to, that similar provisions are already very common in the tax laws of various states and have always been acquiesced in, or at least, not successfully attacked, and that, as to the matter of self-crimination, even if such a result could follow from the enforcement of any provision of an income tax law, it would be no ground 5 State v. Freer, for adjudging the whole statute unconstitutional, but only a matter to be pleaded by the individual in his own behalf when a criminal proceeding shall actually be brought against him and an attempt actually made to use against him evidence thus extorted. 9628. Apportionment of federal income tax. The United States Income Tax Law of 1894 was adjudged unconstitutional on the ground that it was a direct tax within the meaning of the Constitution of the United States and yet was not apportioned among the several states as that instrument requires. 97 The Corporation Tax Law of 1909 was also not apportioned among the states, but its validity was sustained by the Supreme Court, on the ground that it was not a direct tax upon the income of corporations, but an excise tax upon the conducting or carrying on of business in a corporate capacity, and that there is nothing in the Constitution requiring excise taxes to be apportioned according to population. 98 So far as regards the present income tax law, and any future law of the same character, the necessity of apportionment is dispensed with by the 16th Amendment to the Constitution, which provides that the Congress shall have power to lay and collect taxes on incomes, from whatever source derived, without apportionment among the several states, and without regard to any census or enumeration. Flint v. Stone Tracy Co., 200.
All right, that's it, guys. This completes the next section of the treatise on income tax. Hopefully, you guys learned some most juicy tidbits in there. So, as you guys can see, once again, to all my loves, all my haters, it is what it is. You do your own research. But when you start to overstand the law and what they're saying here, it's pretty clear. There are people who are taxable and those who are not. You need to know who you are, what source, where you work, and those things. And then you'll find certain things do not apply to you, but they can apply, and you can do certain taxable events. It's a very sticky quagmire. So that's why if you need some navigation, reach out to me and my team. We will help you out the best we can. All right. But remember, we are not tax experts. We're not giving tax advice. We're just giving you private consultations on potential avenues for private individuals, private citizens on matters of finance and debts, I guess, if you want to look at it that way too. So that's it, guys. Take care. I'll talk to you guys later. Thanks for watching. Don't forget to hit that bell, like, subscribe. The next video will be popping up sometime soon, about now. And that will take you through the rest of the course. And as always, check out the course playlist. Watch the Getting Started, the Right to Travel, and the Passport videos, or whatever courses that you guys want to take. And check me out over on blacksite32.com, jamesclovett.com, and my various other YouTube, or, well, I should say my various other social media platforms. There you go. All right, guys, I'll talk to you later. Enjoy yourselves. Enjoy the day. Stay warm, stay blessed, stay in light. I'll talk to you guys later.